All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our case number CV150016, Zwar versus Swain. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal. Counsel, you need to keep track of that time for yourself. We have conferenced this case, and we have discussed the issues involved, and we're familiar with those. Would each of you identify yourself and the party you represent as you begin your argument? Counsel for the appellant may proceed.
Good morning, and may it please the Court. My name is Maxwell Mahoney. I am counsel for the appellant in this matter, Earl Swain. I think that this case presents three interesting issues, the first one being the status of Judge Hicks's order prior to the last appeal and what it meant for the remand hearing. The second issue being the ability of my client to retire, and the third being the attribution of income to my client as he has voluntarily retired. I'd like to start with the vacated order, unless this Court wants me to start with one of the other issues for any reason. Okay, the vacated order. So Swain v. Hicks, found at 235 Errors 209. The conclusion was, accordingly, the family court should not consider Burrell's Title 38 service-connected disability benefits in calculating spousal maintenance award. Therefore, the ruling is vacated and the matter is remanded to the family court for further proceedings consistent with this opinion. The issue on the remand hearing is that prior to the hearing starting, Judge Ryan took counsel into chambers and said, I'm going to adopt.
Where is that in the record?
That's not in the record itself, Your Honor.
It's not in the record.
But at the same time, there are two objections. There's bookend objections by trial counsel, the beginning at the end, a transcript, page 36, lines 3 through 37. Page 36, line 3 through page 37, line 2, page 104, line 22 through page 105, line 16, stating that trial counsel took issue with Judge Ryan using the findings adopted from Judge Hicks's order in the remand hearing, stating that we have an issue of the attribution of income issue is still an issue on appeal in the special action. It had its own subsection in the special action. It wasn't a resolved issue, but that all of those findings, everything from that Judge Hicks's original order all the findings should be vacated, null, and we should have a new trial on all those issues, and you should have to go through the process of making those findings again. The trial court did not do that.
The special action didn't the only issue that was resolved by the special action was the using of a source of income that the trial court shouldn't have.
That's correct, but the issue was still raised in the special action. While it wasn't
but if it wasn't resolved,
I understand.
It wasn't resolved.
I understand, but at the same time, what we're asking is the issue is attribution of income was still an issue on both parts, and that the trial court just adopted Judge Hicks's findings on the attribution of income, and that my client was able to work part-time and a job that he's never worked, which we'll get to in a second. Moving into whether or not my client is able to retire, we think that Cheney applies and Cheney controls. In that case, the husband sought to terminate his spousal maintenance obligation. The court in Cheney found that he was 65, so he's retirement age. He had numerous medical issues, and that he retired in good faith. And because of that, the court in Cheney found that the husband's retirement was involuntary. He had to retire. He had no choice.
You know, I don't disagree with some of the elements of Cheney. You've summarized it accurately. But every case is different.
Sure.
Every case is different. And the trial judge here heard a lot of testimony about your client's medical issues and heard quite a bit of testimony about, I'm going to call her by her first name without any disrespect, Diane's medical issues and their employment opportunity or lack thereof and their history, and nevertheless imputed income. recognizing that there was evidence, I believe, that your client is making charitable contributions and apparently has some disposable income. And when we look at all of these facts, just because in one case, one set of facts, the court reached a different result, doesn't foreclose the result that the trial judge reached here.
And I understand that, Judge Norris, but I think, though, is that the facts were rather similar between Cheney in this case, specifically the age of the husbands in both cases. The husband there was 65. The husband here was 66 at the time. Mm-hmm. He's 68 now. Mm-hmm. Both parties had substantial medical issues. My client detailed his repeatedly. The record is chock full of all of them. Our brief, pages 11 through 12, trial exhibits 57, 80, and 102. Then the transcript, page 39, line 19 through 23, 46, line 11 through page 47, line 8. There's a ton. There's a lot. And I understand that those are brought out, and there are some differences, obviously. Every case is its own animal. There's no way around that. But the similarities are pretty striking between Cheney and this case, I still think. That the basis of what Cheney said and the boiled down essence of this case are that the two husbands were retirement age. They both had substantial medical issues. And there's not a whole lot of instruction from the Cheney court on how they found voluntary retirement or involuntary retirement there. But the evidence in this case shows that Burrell, and I'll just use his first name also, Burrell he tried to find work. He tried to find work repeatedly. He went to the places that he had worked at in the past as his traditional field of income. No one would hire him there. And he even tried, as Judge Hicks suggested, this retail work that he's never worked in before. He tried. He applied to, I believe it was Lowe's and Home Depot, and they never even called him back. So no one will hire him. There's no option for him to do.
The evidence was presented to Judge Ryan, and Judge Ryan stated that Burrell had not met his burden of proof on the issue. And that tells me that he made I'm intuiting within that there's some credibility issues here. And for example, let's say that your client files another motion to modify, but this time has a real detailed, verifiable record of, I went to Macy's, I went to Penny's, I went here for retail, and they're just not hiring. A different set of facts. Now we have perhaps some evidence that supports his statements that he can't do this. I had the sense that the court just didn't really put a lot of credence in your client's testimony on that point.
And I understand where you're coming from, Judge Norris, but at the same time, there wasn't a finding that he wasn't credible. There was just a finding that...
but the judge sits as a finder of fact.
Sure.
And juries don't return findings typically unless we ask in special interrogatories or the like about issues of this nature, but that's kind of implicit in what the court found when he didn't meet the burden of proof.
And obviously we disagree with Judge Ryan. That's why we're here, essentially. But we do think that Burrell produced sufficient records. He showed his applications, the emails. He detailed his work history, his use of a headhunter to try to find him work somewhere to do something. He was looking for something because of this issue. But he could find nothing. He couldn't find anything. One of the reasons he proposed was because he's too old, or as he called it, he's old technology. The other one is he does have...
Be careful. Some of us are in our 60s, so...
No one here is old technology. You guys are fine. Okay. But
thank you.
The other part of it is his medical issues they're an impediment to him working. Mm-hmm. They're an impediment to him working in any field at this point. The other part of this is there's no position from opposing counsel or Diane that what he could do. And in fact, the record is interesting on trial counsel asking Diane, what can he do? Do you think he can work? She just, no, I want my money, I want my money, I want my money. And that's in the record from, transcript, page 96, line 18 through page 97, line 10, page 98, line 10.
Well, clearly there was no love lost at this point.
Not at all, not at all.
And she had, keeping in mind the parties were divorced in 2005, she probably didn't have any idea. I mean, she wasn't in his life.
Sure.
Yeah.
So. But at the same time, for the court to attribute him income based on a field that he's never worked in, the evidence shows he's never worked in that field, there has to be some kind of position there. There was no basis for it, for her or the judge, for the judge to really.
But who has the burden of proof to show that?
Well, it would be, I guess, my client to show that. But at the same time, who presented evidence that he could work? He presented evidence that he tried to find work in these fields, that he did apply to retail jobs, that he couldn't get those jobs.
Just two.
Home just two, at least, that were on here.
Was it Lowe's?
Lowe's and Home Depot, sure.
Right. What about others?
I mean, he submitted a bunch of other applications everywhere else. And the other part of this that we've kind of detailed in our brief is that it should be his appropriate income. We think that factor should kind of flip around for the obligor also here. That kind of goes towards the attribution of income issue. So, for example, here he worked as a project manager for years. That was kind of his job. And what Judge Hicks and what now Judge Ryan has said is, yeah, you can't find work in that area. And you've detailed that. And Judge Hicks found that, and Judge Ryan, it seems, kind of the same thing. But you can go ahead and work in a retail facility for part-time, for minimum wage. That's not his income. He doesn't have any experience in that level, in that field at all. That would be, it'd be similar to, pilots are mandatory retire around 65. Okay, you're no longer a pilot, and that's what you've done, for the last 40 years, let's say. But you can go dig ditches, or you can go be a greeter at Walmart. Well, then is anybody ever able to retire and be retired and not have to work for an income if they have a spousal maintenance obligation? It would seem no, because there's always going to be a job on that reasoning. There's always going to be a job that somebody can do. So if you were you're an attorney or a CEO or something, and you have a spousal maintenance obligation, and you can't get a job anymore because you're older, you have medical issues, etc. You can't find work. You've done a diligent job to try to find work, and you go to court and say, "Hey, I can't do this anymore." The judge says, "Well, you can probably work retail because most people can work retail part-time, no big deal. You can make the $948, or you can make that payment, no big deal." That's a problem. That's not appropriate income. That's not what he's done. So we take issue with that, obviously.
Well, and ultimately one of the problems with respect to all of this is, given the lengthy marriage, and depending upon how long people, because as a family court judge, I've had that situation where, people in the 80s, we were attributing income, and maybe they could or couldn't, but we get to look at, these facts in light of the record here.
I think the attribution of income, altogether the issue is interesting, but in this case, where we're positing that Burrell retired involuntarily, he couldn't find a job, that's what we're arguing. That to attribute him any income after that there's no basis to do so, and it's unfair. So what you're saying is, you've never worked in this area, you haven't shown that you got a job in this area, but at the same time, we're going to go ahead and attribute that income at this area. And what's he supposed to do now? He can't get a job. He can't find a job.
I think and I know we've had this discussion, but we do not sit as a finder of fact.
Sure.
We really don't. And maybe if I had been the trial judge here, I perhaps would have ruled differently. But when the court says categorically he has not met his burden of proof on this issue, I think the court has necessarily rejected his testimony, and that's a factual matter. And I struggle because our standard of review leaves factual determinations like that to the trial court and requires us just to review for abuse of discretion.
Well, we're asking for de novo review on just the attribution of income at the same time, we think that Cheney was misapplied here. He's retirement age. Again, it goes back to he's able to retire.
I'm retirement age too, and I'm still plugging away.
Sure. Sure, but you have a job, you're here, you can get a job. He can't. That's the difference here. He's retirement age and he can't work. Not only not in his traditional field, but in any field. So if he's of retirement age, he can't find a job, how can we attribute to him any kind of income? And I think that the retirement age issue and the ability for him to really find a job are, I think, in the record shows, I think it's adequate. Let me just look through my notes, I apologize. And one of the things that my friend has brought up in her brief of the statement that Burl made that he wants to work till he's 70, and I think that counsel kind of relies on that a few times. The full quote of that is in the what would be titled transcript 2 from the from in front of Judge Hicks at page 75, lines 6 through 14, when they're discussing him going back to work for. They're discussing what he's going to do going forward. And he says, I cannot work in what I'm doing. I've tried to find a job. If someone can give me a clerical job, I'd try to work a few hours a day. If I could get a manager job again, I'd come back out of retirement. I would like to work till I'm 70. Then the remainder part of that is, but I haven't been able to. And even at that time, he hasn't been able to find a job. And interestingly, in that same transcript, if you go to page 50, lines 21 through page 51, line 8, counsel's asking about the fact that he went back to umpiring for a little bit, and his response was, because I had no money, and he stops, and I had to pay too much money. I couldn't live. I either had pain, or I don't live, or I go to jail. So you have a man who's trying to do something here. He's trying to live, and he's trying to meet his obligation that he cannot meet on what he's got right now. He simply cannot meet his obligation, and he can't find a job, and he can't make money. So again, looping back around, we believe that Burl is retirement age, can't find a job. He's got significant medical issues that are detailed in the transcript in our brief, in the trial exhibits 57, 80, and 102, like I said. And under Cheney, we think that it's sufficient for him to be able to retire and not be attributed income. We don't even think that we get into the Pullen analysis because it is an involuntary retirement. Unless there's any other questions, I'm actually going to go ahead and reserve the rest of my time for rebuttal.
Thank you, Mr. Mahoney.
If it may please the court, Amber Guyman on behalf of Diane Swain. I'm a little bit curious as to why we're here today. I think it's really good that we're here today because there are some questions in my mind that I think could be answered here. However, my curiosity lies in this specifically. If this court refers to the trial transcript from the hearing held before Judge Hicks back in July of 2013, husband testifies on page 9 specifically that it is his desire to pay wife $400 a month until she's 66. Then, at the evidentiary hearing, Mr. Swain gives what I will refer to as trial testimony version 2.0. In that version of his testimony, he has now taken the middle ground of that, and he proposes to pay, according to pages 42 to 43 of his sworn testimony in August of 2014, $350 a month for 2 to 3 years. In 2 trial courts, he himself asked to pay some spousal maintenance, roughly $300 to $400. The trial court in this matter entered an order, the trial judge entered an order for $493. Is this a significant or substantial prejudice to husband? I would argue no, not when you take into account the cost of appealing this matter, his right to modify again, as he has done multiple times now. So while I just want you to keep that in mind as I proceed forward a little bit with some of the relevant pieces that I wanted to address today. I think...
Have that page reference again from the 2014 transcript?
Yes, August 5th of 2014, pages 42 to 43.
August 5? Did I have that right?
I believe that is the date of the transcript.
And it's pages
42 to 43.
40. Okay, thank you.
Okay. And I guess it would be good for me too to even point out that in that transcript that of the hearing before Judge Ryan, that Mr. Berkshire, who was representing Mr. Swain at the time, even interjects and during some cross-examination of my client, if I can pull it open here really quick, basically is asking her, I apologize, I got to find this really quick. Okay, well, I'm going to go ahead and move forward, but essentially, it is Mr. Berkshire that is presenting this, as far as split of incomes. If you were to pay X number of dollars, would that exceed half of your disposable income or be equal to? But that is how we came up, from what I'm reading, with this $300 to $400 figure, okay? So I think that the best way to go about really looking at this, and I tried to remain as oriented toward what this court would want to hear as possible, is to take a look at Judge Ryan's minute entry and to also take a look at Judge Hicks's minute entry. So I'm going to get those both out here really quick. All right. Now, in paragraph 2 of Judge Ryan's minute entry, he specifically delineates which findings from Judge Hicks's minute entry that he is adopting. Okay. Now, let's look at those findings, okay, because husband's argument is that we can't even rely on findings. If the Court of Appeals comes back and says, you're reversed, we're remanding, and in this case specifically for the Title 38 issue, which was the matter at hand then, and in addition, I'm vacating the minute entry ruling. Now, as attorneys, obviously, we get really technical. Is it the minute entry? Is the minute entry ruling? Is it the ruling? What part of this are we discussing here? And that is an implication in this case that I think that the Court of Appeals could have done a little bit better job in remanding it back to us.
Different panel, not us.
Right, no.
And you need to keep in mind that a special action is a separate action that addresses only what it addresses. It's not like an appeal that involves any kind of thorough review of the whole case, because the whole case doesn't come here.
Exactly.
So when with the special action, we only take whatever action that we define in the order, and it's limited to what we reviewed in the special action.
Right, and I believe that's what was stated prior. Is it was very specific when the Court of Appeals ruling came back from the Special Court of Appeals. It was, you can't take into consideration Title 38 benefits. Clear statutory issue. We go back, okay? And husband is correct in that he did raise the issue of whether or not the judge was correct in assessing some sort of or attributing some sort of income to him based on what they believe is inappropriate income. So Judge Ryan took that and ran with it. He said, I looked at the record, and if you look at the page 4 of the transcript from that hearing, he says specifically, I'm not predetermining an amount. I'm paraphrasing here, not quoting. I'm not predetermining this, but I've gone through the record. I've looked at what the Court of Appeals has directed me to do, and that's what I'm doing here. So back to this argument that, you know, we can't look at any of these findings. It's kind of a forceless argument, because when we look at he says he adopted the following. Subparagraph 1, standard of living established during the marriage. It was previously found by Judge Goss that the parties lived comfortably. All he did was take what Judge Goss had found back in 2011, which was undisputed by either party from 2011 until the 2013 proceedings. Number 2, the duration of marriage. Again, no real, it's form over substance. Not an issue, it's a fact that's going to exist nonetheless. Factor 3 I will come back to. Moving forward to factor 6, contribution to the earning ability of the other spouse. Factor 7, factor 8, factor 9, even factor 10. All the way through factor 9. All Judge Hicks did was go back and refer to Judge Goss on those items, and that is not a matter up on appeal. And again, those were facts, those were findings by Judge Goss that were not disputed by either party in this matter. And I don't think that we need to ignore the court record in proceeding forward. That would make your job very convoluted and my job very difficult to go back and piece those facts together.
Besides, I mean, it would seem every time you're doing a modification, you'd have to have some understanding of what's come before.
Correct. So the only factor, I mean, giving them the benefit of the doubt, the only factor that Judge Ryan adopted that I think may be disputable based on the record as it exists is potentially this number 3. And if we go back to that and you look at what Judge Hicks laid forth, much of it is fact-based. Petitioner is 62 years of age. At the time of the divorce, she was not working. These are facts that are not disputed. And Judge Hicks goes on to say, petitioner testified that if she's no longer able to work, petitioner further testified her monthly expenses total $3,000. These are the same that existed.
Yeah, I think perhaps to make your point, having compared the first order to the Judge Ryan's order, really the only significant issue in dispute is the attribution of income and whether Burrell should be imputed as being able to work. And that really, the critical language was the language that Judge Hicks had in finding number 4. And that is what Judge Ryan said was he would take it up. And so that's really what's in dispute here.
Right, and that's exactly where I was getting to. I mean, the points that Judge Ryan did pick out to address based on the Court of Appeals findings, based on his review of the record and the information he had in front of him, those were the disputed issues. And I would agree based on what we had in front of us at the time. Now, however, this gets a little tricky because, you know, husband's arguing a vacated judgment puts the parties in the position they held before entry of the judgment. Okay? It's really important what husband's testimony was before Judge Hicks, because if we're doing that, if we're doing what the case law suggests now, mind you, none of the cases presented by husband are family law cases. So we have some really unique circumstances here, right? Unlike a criminal conviction, spousal maintenance changes over time. All the circumstances are constantly in flux. So how do we handle that? I have no really good solution for today, but nonetheless, husband's position is that the vacated judgment puts the parties in position they held before entry of the judgment, citing Nilsen v. Patterson, Arizona, 2003. So if we go back to where they were at that time, that testimony is very relevant. That testimony before Judge Hicks is very relevant. And husband would like to sidestep that testimony because in trial before Judge Ryan, or trial testimony version 2.0, he changes his testimony.
Well, one of the things, perhaps this is in the record and you can point it. I did not see where Judge Ryan made a statement that he had reviewed the prior testimony. I don't think he said that. And I didn't see in the record any place in which your client said through trial counsel, Judge, we're incorporating by reference Burrell's testimony or Diane's testimony here. So I don't know if he ever went back and looked at anything that happened. Clearly he had the evidence was presented in 2014, though.
Correct.
Right.
Yeah, and I mean, if I recall correctly, I believe I did designate portions of the trial transcript in advance of the evidentiary hearing, the prior trial transcript, and I did go through and ask Mr. Swain questions based on that prior testimony, such as, so...
For impeachment or...
Correct,
or
correct.
party admissions. Okay.
Yes, yes. So if we go back to Judge Ryan's minute entry, there again, I think the main argument, going back to what you've addressed here, is the, was it improper, abuse of discretion to attribute him some income? Now, in my reading of the minute entry, I don't think that this court can say whether or not the trial court attributed him an income or looked at his lifestyle and some of the things that we were alleging at that time, which were contributions to his living expenses by a significant other. Husband testified on the stand during 2.0, essentially, that it did reduce his cost of living. His girlfriend did cover some of his expenses, and that has been one of our arguments that has come up repeatedly throughout hearings. And I don't believe that opposing counsel's assertion was correct when he said that Judge Ryan, I don't see anywhere in the minute entry where Judge Ryan is saying, I don't think that he's able to work in this area or this area. And he himself, Mr. Swain's counsel raised, he did testify before the trial court, I could work as a manager, I could work in some clerical capacity. So, there was plenty of evidence on the record and testimony to support Judge Ryan's finding that husband had not met his burden of proof. Now, husband did not request findings of fact and conclusions of law. We can't take the court finds that Mr. Swain has not met his burden of proof from page 3 and put it with a paragraph from page 2 or page 1 and say this is where Judge Ryan drew his conclusion, from what source, and as you stated, he did. He reviewed medical records. He even had the testimony of a witness that testified in the first trial. The record was also void of some really important things. For example, a husband made claims of a headhunter, for example, interviewing or trying to work with a headhunter. If that were my client, that would be the first witness I would call. There was no headhunter as an expert witness or even a lay witness for that matter. The resumes that were presented by Mr. Swain, if I recall correctly, were very limited in the span of time in which he was trying to seek them. There were some in there that said you can follow up as of this date, no follow-ups. There was also other information in there. I think I had looked through there, and what we found was that there were no necessarily, reapplication when he was offered the chance to reapply. And if he were doing, as he testified, looking for jobs, he said basically, find a job for me and I'll work it. He was open to all sources of income. And furthermore, Judge Ryan didn't go back to Judge Hicks's minute entry and specifically state he needs a retail position. That was not his position at all. He looked at the facts as they existed at that point in time. But I think all this still begs the question, can husband change his position on remand from trial before Hicks to trial before Ryan? I would argue no. I think the evidence was as it existed, and based on case law, it was as it was prior to entry of the judgment. Now, in his...
You could probably change your position if you have something that supports your change in position.
Correct. So, and that's exactly what I came here to argue today, is that, there still needs to be notice of a changed position. In essence, the change in testimony from the hearing before Judge Hicks to the hearing before Judge Ryan constituted yet another change of circumstances.
Well, let me take issue with that. This court clearly set aside the determination of spousal maintenance because of the inclusion of the disability benefits. So what was before Judge Ryan was a request that spousal maintenance be modified. 2 years or thereabouts had progressed. That's for time and water under the bridge. And so the court was required to look at the conditions as of that time. I don't think Burrell was required to have locked himself into stone like a pyramid and say, well, okay, I'm now locked back into 2012 or thereabouts when I first petitioned. The court was required to look at the situation as it then presented it. The situation was presented to the court, and it did that. So I'm not sure. If you want to make that argument, please do. But I'm not very persuaded that he was locked into the facts that existed in 2012 or when he first petitioned for this.
Sure. And I appreciate that input because to me this hasn't been very clear. If we're relating back to the petition as filed by husband originally, okay, shouldn't there be an amended petition if facts have changed such that husband's no longer willing to work, he now wants to retire? That is different.
Well, there's a joint pretrial statement that was filed at Record 114 that laid out his position in some detail.
Correct, but still...
And yours as well, and I think there are some statements in there that, for example, I'm looking at the joint pretrial statement at what's on my computer at PDF 11. This is Record 114. First, simply put, husband has a right to retire, as he is now underscored 66. And he should not be forced to work to support wife, and goes on, significant medical issues and so forth and so on.
Correct. Yeah, and I don't obviously dispute what the record says on those topics. Let me gather my thoughts for just a minute. And just note for the record, I do think that poses some due process problems, because if wife's getting notice in a pretrial statement a week
Well,
or
it doesn't
2
matter.
weeks prior.
You didn't raise the issue, so it's
Right.
not here for us.
Yeah, it's just I suppose that's an interesting issue for another day. Okay. Now, with respect to the employment, I think that the best facts in support of the court's findings were not only husband's testimony, but the minute entry itself, where it states specifically he's not met his burden of proof. The court did not delineate specifically everything that it considered. However, the court's minute entry, or the trial transcript, along with other items, did show and lay forth that, he had reviewed the record. He had reviewed everything that he thought necessary. He listened to the testimony of all these witnesses again. So he did consider all the information presented by Mr. Swain on that date. And some very relevant testimony, as you pointed to, the continued charitable contributions, a husband's testimony that he did receive some level of support from his current girlfriend. There's a lot of income areas where he could have been given an income. I don't think it's clear that the court said we're doing this based on this particular number of hours at this particular wage. Perhaps that could be deduced from the record, but it is not expressly stated by Judge Ryan, and we shouldn't be making those kind of inferences under these circumstances. A husband does have the right to retire, and the court does have the right to look at the facts surrounding those circumstances. And there are very pertinent facts here and very unique circumstances, as were testified to at the time of trial, that should lead the court to make a determination based on the totality of everything involved, not just the retirement. And again, I want to go back to, even if this were error, even if the court found that this were error, it's our position that there's nothing in the record that points to error. Or an abuse of discretion, nothing that rises to that level. But even if this court were to find that, again, I want to go back to my beginning statement that it was harmless. He himself had proposed to pay $300-400 a month. He had the right to modify thereafter. And a really interesting part of this is his proposal was to pay the support for 2-3 years per his testimony. Well, now we're 2-3 years out. So if we go back, we're going back to that date, and now, based on his testimony from them, it would be his position that she received nothing. I believe Cheney and Pullen are both distinguishable on the facts, and opposing counsel even said we don't even need to get into that analysis.
Counsel, I'm afraid you're out of time.
Oh, okay. That's all I have to say then.
Thank you for that.
Thank you. I think all my papers were covering up my time. It's typical of me.
It's a learning experience.
Okay, I just wanted to address a couple things that counsel brought up. The first thing is using her phrase of testimony 2.0. Judge Norris, there was about 2 years between the two, and my client testified that in between, significant health problems arose, and one of the main ones was E. coli attached to his heart, and his heart's only working at 65%. His PTSD rating increased. A lot of things happened in those years. Burl's not in good health. He's not. He just isn't. So 2 years, a lot happened between those two times. So his ability to work and his desire to work, even within those 2 years, decreased. I mean, if your heart stops working 35%, and you're up around 66, and you're going to 67, 68, yeah, his determination on his ability to work, it went away. He didn't want to work anymore with those kind of health issues, and with his PTSD also increasing. I also wanted to go towards the adoption, the difference between Judge Hicks and Judge Rines' minute entries. Interestingly, Judge Rines said that he wasn't going to really adopt the findings from, I believe it was paragraph 4 and 5. However, Judge Rines stated on page 1, the last paragraph there, he imputed income to Burl at $948, which was minimum wage for 30 hours a week, which is exactly what Judge Hicks said she was going to impute. So there was some kind of determination of this is exactly what I'm going to give him. There wasn't a secondary or independent analysis that it seems like. It just, that's what we're going to go ahead and do that. That's his income. So
Well, let's assume for the moment that we agree that it appears, based on looking at everything in context, that Judge Ryan adopted or incorporated by reference Judge Hicks' determination that he could work up to 30 hours a week, imputed income. Yet, again, according to our standards that govern us on review, if in fact Diane presented reasonable evidence that supporting that finding, whether it came initially from Judge Hicks, isn't that what we have to look at?
Well, I think there's kind of some inconsistency, though, because Judge Hicks also found that Burl couldn't referee anymore. He couldn't really work anymore either. And so there's this other finding from Judge Hicks that basically says he can't work in any of these fields, but we're going to attribute it to income. And then there's really nothing from Diane.
Well, that gets to the fact there's competing evidence. Again, on an abuse of discretion standard, we look to see if there is reasonable evidence in the record.
I don't know if there is reasonable evidence, though, from really, especially from Diane.
Well, what about, now counsel
But
said
it's
that.
the court's analysis of the evidence, regardless of what it is.
I understand.
You can put it in. We can't then reweigh as if we were looking at it from fresh eyes.
I understand it, but what I'm getting at, I guess, and I think that kind of got lost in kind of some of the factual, is the application of all these facts to Cheney and how Cheney we still think controls, and that law should have been applied to this case. In the end, what we're doing here is we're trying to decide whether or not we're going to make a 68-year-old man at this point that hasn't had a job in years, has significant mental or physical and emotional issues. Are we going to make him work? Are we going to attribute him some income and work going forward to pay his spousal maintenance? Is that what we're going to do? And under Cheney, I don't think that you can. And under the facts here, I don't think that you can. I don't think that there was a sufficient finding to be able to do so.
Well, before any modification, the court was essentially saying she's going to get spousal maintenance until the end of her life based upon a lengthy marriage. That has now changed.
Correct.
The court made that determination, though Burl would like it to be zero.
Correct.
And it may well end up at some point in time, but at least for here, we've got to wrestle with the court's analysis of the facts as presented.
And part of what we're asking is that the court just say that Burl can retire. He's done. He can't find a job. So take that out and instruct the court below to recalculate without his Title 38 and without him being attributed an income because he involuntarily retired.
But even if he retires, he can still be attributed income for spousal maintenance purposes.
I'm out of time, and unless you want me to answer the...
You're free to. You
Okay.
bet.
I would say that he could, but based on what? His income is Social Security and disability otherwise, and if he can't work, what metric or data do we use to attribute him that income? Thank you.
Thank you, counsel. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.